Hello everyone, welcome to USA State. If you are a green card holder living in the United States, or if you have a family member who is a lawful permanent resident, what we are about to share with you today is something you absolutely cannot afford to miss. The United States Supreme Court has taken up a case that legal experts are calling one of the most consequential immigration decisions in decades. We are talking about a case that directly puts at risk the rights of nearly 13 million green card holders across the country. The real question is, can the government strip your green card away when you return from a trip abroad, even without solid proof of wrongdoing at that very moment? We are going to break down exactly what happened, who is affected, what the Supreme Court has said so far, and what every single lawful permanent resident needs to know right now. If you are interested in this topic and liking this video, please stay tuned until the end of the video. If you are liking this video, please hit the bell button, subscribe, and like it so that you may get updates straight to your smartphone. Now let's get into the video. In a recent development that has sent shockwaves through the immigration community, the United States Supreme Court heard oral arguments on April 22, 2026, in a case known as Blanche versus Lau. The case is named after Acting Attorney General Todd Blanche, representing the Trump administration, and Mook Choi Lau, a Chinese national and longtime lawful permanent resident of the United States. According to sources closely following the case, a final ruling is expected sometime this summer, and immigration experts across the country are watching with enormous concern. The stakes, as you will see, could not be higher. To understand why this case matters so much, let us take a closer look at what lawful permanent resident status actually means. As of January 2024, there were nearly 13 million lawful permanent residents, also known as LPRs, living and working legally in the United States. These are people who hold what is commonly called a green card. Despite the word permanent in the name, this case is now putting that so-called permanence to the test. Before this legal battle, most green card holders had a reasonable expectation that when they traveled abroad and returned home to the United States, they would be treated as returning residents, not as new arrivals seeking admission for the first time. Federal law under the Immigration and Nationality Act, or INA, has long included protections that generally shield lawful permanent residents from being subjected to inadmissibility grounds when they come back from international travel. In other words, the law was designed to say, "Welcome home." However, that protection has a critical exception. If an LPR has committed an offense that would make them inadmissible, the government can treat them as an arriving alien, which dramatically reduces their legal protections. Here is what makes this case different. The case centers on Mook Choi Lau, a 69-year-old man who became a lawful permanent resident in September 2007. Back in 2012, Lau was facing a pending criminal charge in New Jersey for third-degree trademark counterfeiting. Before the case was resolved, he traveled outside the United States. When he returned through John F. Kennedy Airport in New York, immigration officials made a fateful decision. Instead of admitting him as a returning resident, a border officer paroled him into the country pending a deferred inspection. This is a critical legal distinction. Being paroled is not the same as being admitted. Under current immigration law, someone who is paroled is essentially held in a kind of legal limbo. They are physically inside the United States, but legally they are still considered to be standing at the border, waiting to be processed. After Lau eventually pleaded guilty to the counterfeiting charge, the Department of Homeland Security, or DHS, moved to remove him from the country using the inadmissibility track, arguing that the criminal conviction proved he was inadmissible. But here is the core legal issue that has now reached the Supreme Court. The Second Circuit Court of Appeals, in a ruling issued in March 2025, said the government cannot do this. The appellate court ruled that for the government to treat a returning green card holder as an inadmissible alien, DHS must have had clear and convincing evidence of a disqualifying offense at the very moment they made the parole decision at the border. Because at the time Lau returned, he only had a pending charge, not a conviction. The court said the government did not meet that standard. The removal order was thrown out. The Trump administration then appealed directly to the Supreme Court, which agreed to hear the case in January 2026. The Trump administration's argument before the justices is essentially this: border officers should not be required to have clear and convincing evidence at the moment of reentry. The government contends that proof of the criminal offense can be presented later before an immigration judge during formal removal proceedings. Sopan Joshi, the Assistant Solicitor General arguing for the government, told the justices that immigration officials are making these calls in real time at busy international airports, often with limited information available. The administration argues that requiring such a high standard up front would make it nearly impossible for officers to do their jobs effectively. Officials argue that border agents found a criminal record in a database and made a reasonable decision, and that the details can be sorted out before a judge later. But critics and legal analysts suggest the implications of that argument are deeply alarming. If the Supreme Court sides with the Trump administration, the decision would effectively allow any border officer, with minimal evidence and no real-time review, to place any returning green card holder on parole instead of admitting them. What this translates to is a system where lawful, permanent residents who travel internationally could come home to find their green card status suspended, their residency in question, and their lives turned upside down, based on nothing more than a database entry or an unproven accusation. Advocacy groups warn that this creates a terrifying situation for millions of people. Imagine being a green card holder, someone who has lived in the United States for years, raised children here, paid taxes, built a life here, and then going on a family vacation or a work trip, only to return and find yourself in immigration limbo with no clear timeline for resolution. Legal analysts suggest that the consequences go even further. If you are placed on parole instead of being admitted, you may lose your ability to show proof of your lawful permanent residence to employers, to state agencies like the Department of Motor Vehicles, and potentially even to immigration and customs enforcement officers on the street. You could face job difficulties, loss of benefits, and the very real threat of detention while the government slowly builds its removal case against you. Immigration experts note that there are already thousands of lawful permanent residents in situations similar to Laos, and a ruling in favor of the government could affect many more going forward. Now, let us be clear about something many viewers are likely wondering right now. Does this affect you if you have never been in trouble with the law? This is perhaps the biggest misconception surrounding this case. On its surface, Blanche versus Lau involves a man with a criminal conviction, so many green card holders without any criminal record might assume they are safe. However, legal experts are sounding the alarm that the government's broad request before the Supreme Court goes well beyond cases involving criminal offenses. The Solicitor General is asking the court to grant DHS the power to parole any returning lawful permanent resident for any reason based on virtually any information with little to no meaningful review. Immigration experts note that if this power is granted, the government could in theory use it selectively against people based on their country of origin, their political associations, or even their social media activity, all without meeting a high legal standard at the time of the decision. During oral arguments on April 22, several justices appeared skeptical of the government's position, with some expressing concern about the lack of checks on such broad executive power. However, a decision has not yet been issued. Reports suggest the court is carefully weighing the competing interests, balancing immigration enforcement priorities against the due process rights of millions of people who have lawfully made the United States their home. A final ruling is expected by the end of the Supreme Court's current term, which typically concludes in late June or early July. As a green card holder, this situation might feel overwhelming and deeply uncertain. Here is what you need to know in practical terms. First, the ruling has not yet come down. Second, if you have any criminal history, even old or minor offenses, you should consult an experienced immigration attorney before making any international travel plans. Third, immigration lawyers are advising all lawful permanent residents to be fully aware of their legal rights at ports of entry. You have the right to request to speak with an attorney if you are placed on parole or prevented from being admitted as a returning resident. Fourth, keep all your immigration documents, including your green card, passport, and any prior immigration court records, well organized and accessible. Beyond this specific case, the broader landscape of immigration enforcement has clearly shifted. Since the start of the current administration in January 2025, the legal environment for green card holders has become noticeably more uncertain. While in the past, a lawful permanent resident could reasonably assume their status was secure, today that assumption no longer holds in the same way. It is more important than ever to stay informed, stay prepared, and seek qualified legal counsel if you have any concerns about your immigration status. To summarize, the Supreme Court's upcoming decision in Blanche versus Lau could fundamentally alter the rights of nearly 13 million green card holders in the United States. The case asks whether the government must have clear and convincing evidence at the time of a returning resident's re-entry, or whether that evidence can be introduced later. The Trump administration is pushing for broader government power, while immigration advocates and legal experts are warning of serious due process consequences for all lawful permanent residents. The ruling expected this summer will have far-reaching implications for anyone who holds a green card and travels internationally. That's all we have for this bulletin. The USA State Channel provides all necessary visa information and procedures for your U.S. immigration journey. It is important to understand the United States immigration processing steps, visa application requirements, processing times, forms, fees, and more. We will continue to provide all information about U.S. visitor visas such as B1 and B2, work visas such as L1A, L1B, and H1B, student visas, green cards, immigrant visas EB1, EB2, EB3, EB4, and EB5, and family immigrant visas. Thank you for visiting us today, and we'll see you in the next video. If you haven't subscribed to our channel, please subscribe to the channel for more USA state immigration update videos.